Hello everyone, my name is Nayeli Arriola. My topic for this PowerPoint is testamentary capacity. I hope you guys enjoy. I will begin with my introduction. This PowerPoint will help explain the importance of leaving a testament in order to avoid disputes between individuals. A testament is one of the most important things that anybody can do for themselves and their families. Have you ever heard a family member, or maybe even yourself, debating if you will keep a family member's fortune because he or she is rich and there's a great relationship between the two? The individual can decide who will keep their property, their money, and most importantly, trust somebody that can make important decisions when it comes to their health. When the individual is mentally incompetent to do so, unfortunately, sometimes individuals do not have anybody or do not prepare themselves with a testament. An evaluation is required in order to decide who will be keeping their assets because they are mentally incompetent to do so. As you are able to see here, when an individual is mentally competent to make their own decision, it's easier because they advocate for themselves. As the author Melton highlights, they can understand legal requirements, administer their belongings, understand what is best for themselves, and they are able to choose who they want to manage their health, and they understand legal requirements. In this next slide, I will be speaking about the presence of a mental disorder. Unfortunately, in many cases, there's a mental disorder that affects the individual's capacity to make decisions. These are some of the red flags that can help identify when a person is incompetent to make big decisions. For example, it is questionable when a person with a mental health disorder can make a choice or perform a duty, doesn't understand how to handle large amounts of money, it's not able to recognize self-determination as a basic principle of human relationships, when there's a sign that significant harm to another individual will result from their actions. Although it's not just observing the individual's capacity to understand those areas, the clinician will evaluate the risk of incompetence by using an assessment tool. The tool that is used is the MECAT. It is used to assess capacities related consenting to treatment. The information that is used is to identify if participant is able to reason his or her thoughts and understand what they are saying. The tool evaluates participants' abilities like understanding, reasoning, appreciation, and ability to express a choice. In some jurisdictions, attorneys may advise their clients to seek an evaluation of capacity at the time of execution of the will, with the attempt to reduce the possibility of a contestant later. With some cases, it is recommended to use video recording. It provides evidence of the testator's mental condition. If the individual is not alive, they will have to gather information from other sources like family, friends, medical records, or other sources that may be helpful in order to determine information on the individual to proceed with the will. What the testators need to know. Testators must know at the time of making their will that they're actually making a will. They must know the range of their property. They need to know every detail concerning the property. For example, how much is their property and how many properties do they have. They must know the natural objects of their bounty. If there's a prejudice from the testator against another individual, it does not automatically render the testator to continue with the will. For example, if there's a dislike for a particular individual, no matter how ill the testator is found, it's not the same as a lack of capacity or a simple belief on the part of a testator that another party has been attempting to injure him or her. That is why it is very important for the court, the clinician, to be involved in a case. For example, also, let's say a cousin who lives miles away, and as a result, the testator do not include him or her as a beneficiary. The will does not automatically get invalidated. The testator must also know the method in which his or her belongings will be distributed. I will speak about the importance of guardianship. Guardianship is a legal mechanism which the state delegates authority over an individual's person or estate to another party. It is probably the most ancient aspect of mental health. It gives the person who is no longer capable of caring for their fortune the right for them to continue keeping those valuable assets. Although they might be under the care of another person, if the court has decided that the client is no longer mentally capable of doing so. Although each guardian comes with its pros and cons. For example, if they do choose somebody from the government to provide services, that can be a social worker, a lawyer, or sheriff. Sometimes they do provide a service with a fee, and sometimes they don't charge a nominal fee. But the con with that will be that they are careless about their will, the fact that they don't have a close relationship. In the other side, when a family is chosen, there may be other disputes with other family members about the use of that money and how they are using it. It could be seen as wrong by other family members. I already spoke about the importance of a guardianship. Now we're going to talk about the types of guardianship. Today, guardianship is established in many ways. Guardians are responsible for different areas appointed to one person. For example, there is limited guardianship, general or plenary guardianship. For limited guardianship restricts the guardian from many things, like making big decisions with their money or property. They're able to spend up to $100 a week and consent to specific treatment decisions. A general or plenary guardian has full authority to have control of the person's words or estates or both. They would have the authority to sell the person's property because they have total control over their will. I want to talk about a guardianship decision in case study 1102, page 357 in the book. This is a case about Mr. Galpin. There is several questions that I have due to this case study that is directed from the book, and I want to hear your opinion, but I will be answering my opinion as well due to this case. Mr. Galpin experiences multiple arthritis, cerebrovascular, and a heart condition. A psychiatrist also observed that Mr. Galpin experiences delusions, hallucinations, and an unspecified mental disorder due to a psychological condition. He is not able to manage his affairs, but he still does, and due to that, he has a balance of $350 in his checking account. Mr. Galpin receives rent and $900 in Social Security each month. Mr. Galpin is constantly at the petitioner's home where her and her mother take care of him, which it is not highlighted who her is in the book, which I do question if it is an immediate family or another relative. It is also stated in court that Mr. Galpin says that he worked for Obama, and his petitioners highlight that he goes outside without clothes, wearing only slippers in a very cold weather. The question to Mr. Galpin's case is, should the court appoint a guardian or consider another method of monitoring him or allow him to be left alone? If a guardianship was considered, would he require limited or plenary? I would say he is not to be left alone, and I would choose limited guardianship because the fact that he's hallucinating, I wouldn't feel comfortable putting all of that responsibility in another guardian, especially if their safety is at risk. Mr. Galpin needs of a facility where he will be provided with immediate professional attention. Here are the conclusions of the PowerPoint. The conclusions are that an evaluation is important for the safety and to protect the assets of the client. A guardian will be appointed by the site if required, and there are legal requirements in a testament in order to continue with the will. End of PowerPoint presentation. Questions. Why is a guardian important? Who can be named as guardianship and who appoints them? Why is it important to be mentally competent when creating a will? Who charges a nominal fee for their services? This is my reference page. I used all the information from the psychological evaluations for the courts book that we have been using for this course. I hope this PowerPoint was informative and you enjoyed watching it. Thank you.